welcome to the last session of our conference. It's a great honor for me to present Dr. Rainer Huhle. He holds a PhD in political science, and in 1989 he co-founded the Nuremberg Human Rights Centers. He teaches transitional justice at the Master in Human Rights program at the University of Erlangen, where I had also the honor to be invited to give a lecture. And since 2011, he's member of the United Nations Committee on Enforced Disappearance. He allowed me to say what I'm going to say now. When I went to the university, he presented me and it was great to meet the students, but I told him and I told to the students that it was a great honor to know him and to have the chance to say that he's a friend and that I admire him. So thank you very much, and please, the floor is yours. You're going to talk about one specific point, and it's called Declaring Human Rights and Punishing Their Violations, a Strange Divide. After that, Dr. Dietrich will close the event, and we will hope to see you again in our next conference. Please.
Thank you very much, Eduardo, and of course, thank you very much to all the organizers, to the Academy, for having invited me to give a final lecture on the overall topic of this conference, which is a bit behind of that, and also of having invited the only native speaker here in the whole conference, because you didn't mention it, but I am a true Nuremberger. I found no better way to open my remarks, but making homage very shortly to Tom Bergenthal, our great friend and honorary president of the Academy. Among his manifold merits that distinguished his career as a human rights scholar and a human rights practitioner, the judgment of Velázquez Rodriguez versus Honduras, which the Inter-American Court of Human Rights issued under his presidency in 1988, is perhaps the most important of his merits. It was the first substantial sentence of the court, and it was fundamental for the definition of the crime of enforced disappearances and of the legal consequences it produces. And there is one passage in this remarkable sentence which reads as follows: "The international protection of human rights should not be confused with criminal justice. States do not appear before the court as defendants in a criminal action. The objective of international human rights law is not to punish those individuals who are guilty of violations, but rather to protect the victims and to provide for the reparation of damages resulting from the acts of the states responsible." For me, in a nutshell, this is what we have been discussing in these 2 days. Now, I certainly do not want to confuse human rights and criminal justice, as it says in the sentence. I would rather reflect upon the complexities in the relation between the two, which permeates the post-war human rights development from its very beginning. This line of division between human rights protection and criminal justice, alluded to in the Velázquez Rodriguez case, has many dimensions. Just to mention a few of them, it has, of course, a dimension of legal competences, also of legal cultures. It has an institutional dimension. It has a geographical dimension, and we will see it has also biographical dimensions. Geneva is the place where we expect human rights to be protected through political decision-making, like in the Human Rights Council of the UN, or through review of legal obligations of states, like in the treaty bodies. Nuremberg, of course, stands for the landmark in the development of the international effort to hold accountable perpetrators who violate these human rights. Now, Geneva, the Palace of the United Nations, is also the place where you find diplomats, UN civil servants, like here Deputy High Commissioner Flavia Panzieri, and many times full of hope, victims of human rights violations, like the founder of the grandmothers of Plaza de Mayo in Argentina, not always in such a harmonious situation as here. In Nuremberg and any criminal tribunal, in contrast, perpetrators are in the focus. Victims played a marginal role in Nuremberg and at best in their role and function as witnesses. Although the creation of the United Nations and of the IMT occurred at the same time, and although they were inspired by the same effort to combat and prevent the barbarous acts which have outraged the conscience of mankind, as the preamble to the Universal Declaration says, there seems to be not only a geographical distance, but also a deep conceptual divide between the two theaters of action. The institutional, informational, personal, and political bridges between the two are surprisingly weak. I often have asked myself why this is the case, whether this divide is natural and necessary, or rather counterproductive to the common goal of securing the respect for human rights. Let's start with a look back into history. Few people know that this building, the Palais des Nations in Geneva, had in early 1940 two very prominent visitors who did not arrive voluntarily, and their names were Adolf and Joe. And this is the story. A very young man of just 2 years of age at the time, but equipped with special capabilities, crossed the West Wall and the Siegfried Line, arrived at Obersalzberg, took Adolf by the neck, then went on with him to Moscow, disturbing a mass parade and taking Joe also on a common air trip. Next stop, Geneva. This extraordinary feat did not go unnoticed in Berlin. Goebbels was furious and took it as another proof of Jewish greed. Anyway, once the two villains were hooked, the journey continued. And of course, we should not forget that this happened in 1940. 2 years later, after Operations Barbarossa and Pearl Harbor, Superman let loose Joe and lifted instead the Japanese military. But let's go back to the 1940 trip to Geneva. The destination was nothing less than the much despised League of Nations. Superman did not care much about the competences and rules of procedure of this venerable institution. He apparently did not know much either about Montesquieu and the separation of powers. He just jumped in and asked for the judgment on those two power-mad scoundrels, as he called them. And he got it. The League of Nations did realize their responsibility and pronounced a guilt sentence on the two criminals. Superman's behavior here is probably very different from his usual way of performing a more self-styled type of justice. But more important for us here, he was setting an important precedent for the unity of the quest for universal peace, for human rights, and for criminal justice. He paved the way for a lot of followers with admittedly less supernatural powers and of course less success. Some of them we see here. 3 years later, 1945, in a modest room in London at the Royal Courts of Justice. The United Nations War Crimes Commission was founded in October 1943, mainly by representatives of the Nazi-occupied European countries. Among its members were some outstanding legal scholars, and the amazing work of the War Crimes Commission to collect evidence for trials against Nazi criminals and for setting legal principles for these trials has long been dismissed and only in recent years been re-evaluated by legal historians. The very concept of crimes against humanity is essentially due to the work of members of this body. So please give me a few minutes to present at least 4 of the men assembled here: André Gros, Yuen Li Liang, Bohuslav Etcher, and Egon Schwelb. I told you it was also a biographical dimension. André Gros was a French tourist and diplomat. Since 1940, he was a counselor to de Gaulle's French embassy in London. There he joined the War Crimes Commission, and in 1945 he took part in the London conference which prepared the IMT. Later, he was a prominent member of the International Court of Justice and the International Law Commission. Oh, sorry, I forgot to show it. That's him, André Gros. And that's, on the right hand, Yuan Li Liang. He's probably the least known among the important founding figures of the United Nations. He was the first secretary of the Committee on the Progressive Development of International Law and its Codification, from which the ILC followed, and director of the United Nations Division of Development and Codification of International Law. This committee created the International Law Commission, and Liang was involved, among other human rights topics, in the drafting of the Convention Against Genocide. His numerous writings in the founding years of the UN have had enormous influence on the development of the legal foundations of the United Nations. This general here is Bohuslav Echer, a Czech professor of law, one of the leading brains of the War Crimes Commission, and certainly the person who, together with Egon Schwelb, contributed decisively to the coining of the term crimes against humanity. He was also present during the London conference and participated actively in the preparation of the IMT. He interrogated at Monheim, months before the IMT, nobody less than Keitel, Ribbentrop, von Neurath, and Göring. During the IMT, he headed the Czechoslovak delegation. Later, he was elected one of the first judges of the International Court of Justice, handling, among others, the famous Corfu States case. Then he returned to Czechoslovakia, where he taught law, but after the Stalinist coup of 1948, became a victim of persecution. He died in 1954, the day he was to be arrested by the secret police. Egon Schwelb, Czechoslovakian, like his colleague Echer, had escaped just in time from Prague to London and became the driving force of the War Crimes Commission. He was the main author of the Commission's final report published in 1948, and his 1946 essay on crimes against humanity remains still today one of the most lucid texts on the matter. In 1947, John Peters Humphrey, the brilliant Canadian from McGill University, I hope the McGill professor is still here. Yes, you are lucky. Called Schwelb as his deputy. He filled this position with enormous energy, writing for the rest of his life many path-breaking texts on human rights, on all topics of human rights and the human rights policies. The United Nations War Crimes Commission could have been the prosecutorial nucleus of a UN criminal court against the war criminals. But although it had collected an enormous amount of evidence against Axis war criminals, which was also used by the IMT prosecution, the War Crimes Commission as a body was marginalized even before the IMT began its work. The big powers wanted to keep control, so the IMT was only formally an institution of the United Nations, to the disappointment of many of the smaller members of this alliance. And the marginalization of the War Crimes Commission from the IMT was certainly a decisive first step on the way towards the divide between the criminal prosecution and the human rights protection through the United Nations. The personal crossovers we have just seen could not change that basic decision. Little attention is usually given to the fact that the preparation of the IMT and the foundational process of the United Nations, we are here at the Opera House in San Francisco where it happened, occurred exactly at the same time. This is due, no doubt, to the little relationship that apparently existed between the two developments. But was there really no intersection between London, Nuremberg, and San Francisco, New York in 45-46? Well, it was in San Francisco early in May 45 that the British finally gave up their resistance to the trial. But this was negotiated in a separate meeting behind curtains and had nothing to do with the UN conference itself. Perhaps the most visible personal link between the IMT and the UN is Hartley Shawcross, the British prosecutor. His frequent absences in Nuremberg were in part due to his early second job as a British representative to the United Nations. He sat at the legal committee, where one of his minor duties was the decision about what the UN flag would look like. More important was his role as, together with French IMT judge Donieu de Vabres in the drafting of the Genocide Convention. He also was present in Paris when the last touches were discussed about the text of the Universal Declaration. There he met frequently Andrei Wyszynski, the mastermind of the Moscow show trials 1937, as well as of the Soviet prosecution in Nuremberg. And apparently they enjoyed a lot of good company with a guy whom in Nuremberg he had not met very often. Now, the shadow of the Nazi crimes was lingering also over the debates in the declaration. Here we have the Palais de Chaillot in Paris in December 1948. But the vestiges of the memories of these crimes were little by little eliminated from the text. The drafters of the Universal Declaration, with no participation of the IMT among them, wanted a document of true universality, not bound by the specific experience of the Nazi crimes or other horrors of the recent past. Or, as the late Stéphane Hessel, survivor of several Nazi concentration camps and after the war a French staff in the Division of Human Rights at the UN in New York, told me in an interview some 10 years ago in Paris, the people, he said, who drew up the Universal Declaration of Human Rights quite clearly did not want to be influenced by Nuremberg. They believed Nuremberg belonged to the past, whereas they were looking to the future. And he includes himself because he was part of that gang. We were glad for the Nuremberg trials, but preferred to focus on the Universal Declaration of Human Rights. And I think that Hessel touched here an important point in order to understand this divide between criminal prosecution of perpetrators and protection of human rights. Although prevention is at the core of many theories of criminal punishment, the focus of criminal proceedings is necessarily directed towards the examination of the past, whereas at the core of human rights policies is the effort of standard setting with a view on preventing future human rights violations. But in the early days, this divide was not yet fully achieved, and certainly not without alternative, as we used to say today. The Universal Declaration was little solemnly part of just a General Assembly resolution, 2017-3, and was titled International Bill of Human Rights, flatly. Bill of Human Rights comprised, in the terminology of the time, 3 elements that had been given as a task to the Human Rights Commission from the outset: a declaration, a covenant, and measures of implementation. As the declaration was now adopted, the General Assembly in the last section of the resolution reminded in very explicit terms the Commission of the 2 remaining parts of its to-do list. Measures of implementation was a very broad term that included different measures to make human rights recognized and protected, could include education, diffusion, and other software measures, but also stronger tools like a complaint procedure, which the Human Rights Commission and ECOSOC, however, abandoned due to political pressure very early. But among the measures of implementation were also discussed different projects of international courts. Proposals were made for an International Court of Human Rights. Australia presented in 1949 a complete draft statute for such a court. Proposals were made from India, for example, for a human rights chamber at the International Court of Justice in The Hague. And also a standalone International Criminal Court had many supporters already in the early years. It found its way only into the Genocide Convention, Article 6, where it remained unrealized until today, like the rest of proposals of international courts of the time. The only initiative that states were prepared to accept was to charge the freshly established Law Commission with the task of conducting a study about the desirability and possibility to establish international jurisdiction for genocide and certain crimes under international law. Again, Hartley Shawcross and also French Judge Don Dieu de Vabre, here on the right, participated in these undertakings, bringing in their Nuremberg experience. As we know, the study soon concentrated on the work of a draft code of offenses against the peace and security of mankind, leaving aside the question for which kind of court this code would finally serve. And as we also know, the Commission kept on working on this study over several generations, until half a century later, in the summer of 1998, a group of diplomats and legal scholars drafted in Rome their own project and created the ICC. The failure of the UN to complete the triad of declaring, contracting, and implementing human rights by an international instrument, of holding violators accountable, contrasts with the unanimous support for the jurisprudence of the IMT through the Nuremberg principles. But what in London had been devised as a statute for a tribunal became in the UN first a resolution, and then in the International Law Commission, principles without a defined field of implementation. Without doubt, the Nuremberg principles had a lasting impact as orientation for many national endeavors to combat impunity and for developing jurisprudence and legislation, especially in transitional justice efforts, like in Latin America. It is not accidental that the only comprehensive academic commentary, to my knowledge, on the Nuremberg principles was published 4 years ago by a group of Mexican scholars. At the time, half a century after their proclamation, they had already found their way into the statutes of the international criminal courts. But until these post-Cold War developments, they had in the UN just declaratory value. So the study really takes into account all the recent developments in the international and regional courts. Beyond the obvious political unwillingness to implement measures of enforcing human rights, part of the problem lays with the structure of the UN itself. Just one example, the Genocide Convention was approved in the same session of the General Assembly, 9th and 10th of December, but they were developed in different committees, in the legal committee and in the third committee, and they had nothing to do in the preparation. They were even incompetence. So there seem to have developed different institutional and political cultures in the machine room of the United Nations from the very beginning. Differences we can find today, for example, still between Geneva and New York, one the soft law department, the other the hard stuff. And the only link between the ICC, for example, and the UN is through the Security Council, but no institutional link exists between The Hague and Geneva, except the Nuremberg Academy, of course. And the drafting of the Rome Statute and Human Rights Treaties again went along separate paths. And the ongoing drafting process of an international convention of crimes against humanity, I am afraid, will add more to this confusion. But then the early 90s, as we all know, and I don't have to explain it here in detail, brought also surprising decisions of the Security Council, namely to install 2 international criminal courts. First, that peacekeeping and human rights, they made the Security Council, in addition to creating these courts, made indirectly 2 very important statements. First, that peacekeeping and human rights protection are more intertwined than many protagonists on both sides of this other big divide would have accepted. And secondly, that the UN, through its most powerful instance, can create measures of implementation if it wishes, can create instruments of holding accountability perpetrators of gross human rights violations. It can, if the political will is given, at least for a short window of opportunity. But 8 years after the beginning of the atrocities in Syria, to give just the most appalling example, we do not even have the perspective of an international criminal court on Syria, and instead have to content ourselves with a commission of inquiry set up not by the Security Council, but by the Human Rights Council, and which its former member Carla Del Ponte denounced after her resignation in her well-known style as an alibi exercise. It seems that the window of opportunity that allowed for ICTY and ICTR is now closed, hopefully not forever. In view of these complex relations, it came as an interesting surprise, but noticed by very few people, when the Secretary General in 2004 appointed Louise Arbour as the High Commissioner for Human Rights, and thus, for the first time, picked neither a politician nor a UN functionary, but a former chief prosecutor at the International Criminal Tribunals. For the first time, there was at least a personal link between The Hague and Geneva. And this line was continued by Navi Pillai, who had served for 8 years as a judge on the International Criminal Tribunal for Rwanda, and after that for another 5 years at the ICC as a judge. I asked her during this conference whether she felt that this made a difference in the High Commissioner's work, and she said yes, but time was not enough to go deeper into that and ask what exactly the difference was. Anyway, the nomination, beginning in the late 70s in Argentina and soon in many Latin American countries like here in Chile, human rights activists emphasized the fight against humanity. No, not the fight against humanity, the fight against impunity. Leading to what some scholars have called the criminal turn in human rights. And I think the nomination of 2 high commissioners from the sphere of international justice reflects very well this criminal turn in human rights in a way. But more importantly, the World Conference in Vienna in 1993, with an immense participation of civil society. Here we see a group of protesters in front of the buildings. Made very important declarations relevant for our topic here. It said states should abrogate legislation leading to impunity, and thereby providing the firm basis for the rule of law. And later on, it said it views with concern the issue of impunity of perpetrators of human rights violations and supports all efforts to examine all aspects of this issue. And finally, it made a call that all persons who perpetrate or authorize criminal acts associated with ethnic cleansing are individually responsible and accountable for such human rights violations, and that the international community should exert every effort to bring those legally responsible for such violations to justice. The document that in the Human Rights Commission summed up the fight against impunity were from 1993 onwards the different versions of what we call colloquially the Journée principles on the question of impunity. What was the content of these principles? A, the victim's right to know, B, the victim's right to justice, and C, the victim's right to reparations, which included at the beginning guarantees of non-repetition. Now, this right to justice is very interesting because it says any victim can assert his rights and receive a fair and effective remedy, including seeing that his oppressor stands trial. Every right, also the right to justice, entails obligations for the state, in this case, of course, to investigate violations, to prosecute the perpetrators, and if their guilt is established, to punish them. But more important here is that, as I understand it, for the first time in the history of the human rights, the right to justice is declared a human right, which is different from just to declare it a necessity or something. It is clearly among the rights of victims as a human right to justice, a human right that perpetrators are brought to justice. So the Journée principles, here we have him at the age of 80, in the middle of a manifestation against enforced disappearance in Montevideo, Uruguay. These Journée principles today are generally recognized as rights of victims of grave violations. And being only soft law, like the Universal Declaration, their influence in international human rights law has proven to be enormous. They are indeed the common ground, I think, where human rights and criminal justice meet, and where criminal justice for grave human rights violations has its reason and its justification. In our mental maps, many of us have it very clear how human rights and criminal justice are connected. What we are still struggling for is the institutional junction. Thank you very much for your patience and
Thank you very much, Rainer. Hule, that was wonderful, a very in-depth, I think, rigorous journey, taking us back in time and through the developments of the last decade. So thank you very much for that really enriching presentation. Ladies and gentlemen, it is now my pleasure, before formally closing this conference, to once again briefly reflect on the discussions over the last 2 days. In the City of Peace and Human Rights in Nuremberg itself, we've witnessed over the last 2 days a very intriguing discussion that took place on the wider topic of paving the path of human rights, precisely interrogating and identifying the synergies of international criminal law and human rights. Given the breadth and depth of experience and expertise assembled here in this room, we've restated and stated the challenges and problems. We've identified some of the lessons learned. Some dilemmas were sketched. Some policy coherence was actually challenged. Certain proposals, ideas, and suggestions were tabled. Certainly there was a common thread and a common understanding that the UN agenda and the Sustainable Development Goals, especially SDG 16, represents an advance and a significant achievement. That being said, of course, it remains critical to continuously identify and crystallize how far have we come and how far do we yet have to go. We've heard sobering accounts, some words of caution. We've heard utopias being sketched, and we've heard some hopeful accounts, some pragmatic solutions being sketched. And that, of course, was the purpose of this conference, to hear different views, different perspectives, to be unearthed from different fields, different disciplines, different voices. We've had very serious and deep conversations which have unearthed or referred to systematic data. Some anecdotal evidence has been brought here to the account, and then we've heard in panel 1 the symbol of the rainbow actually being painted. The conceptual, the theoretical, the empirical, and the practical dimensions of these discussions on international criminal law and human rights were brought to the panels by our esteemed speakers to really illuminate various facets of the debates, including the political, the legal, the economic, the cultural, and the social facets of, again, this interplay of international criminal law, human rights, and sustainable development. The title of the UN Agenda, Transforming Our World, the 2030 Agenda for Sustainable Development. I mean, this title is telling. There's real ambition behind this. There's a transformative potential that is actually identified. And of course, we have come to begin to unscratch the surface of what that might mean in the last 3 years, and of course, the next years to come, as the Sustainable Development Goals remain on the agenda, and it is important to fill them with life and strategically advance action. Indeed, leaving no one behind as the cardinal principle has been echoed time and again over the past 2 days. The fulfillment of objectives of the agenda and its goals, in particular Sustainable Development Goal number 16, which was of our main concern here, depends significantly on finding the solutions and stimulating action cognizant of local needs and idiosyncratic contexts, multidisciplinary and cross-sectorial engagement, as well as, of course, a meaningful interplay between political will and capacity and empowerment on the other hand. Against the backdrop of this recognition, of course, this conference has explored the invaluable tools and mechanisms that international criminal law has to offer. And our mandate, of course, is to provide a forum for such expert discussion, as well as promote the development, the implementation, the application, and the acceptance of international criminal law and human rights. And if we've made a small contribution with this conference, then the exercise has certainly been worthwhile. We have seen discussions on the commonalities, on the divergences, but also convergences between international criminal law and human rights, and it certainly isn't to gloss over any convergences, but really to identify and interrogate these synergies. By that, we may have advanced the discourse and propelled action in order for the right conclusions to be drawn, the right decisions to be taken. the right investments to be made that will increase access to justice, meaningful conversations, and strengthen the rule of law and fight against impunity worldwide. As Antoine de Saint-Exupéry once said, "Un objectif sans plan s'appelle un vœu," which may be translated as "a goal without a plan is only a wish." And in order to not relegate the Sustainable Development Goals to mere wishful thinking, I think we're all called upon to dedicate and devise these plans in order to implement the action and make real on the promise of leaving no one behind. So SDG 16 on peace, justice, and strong institutions, there's certainly a room for critical appraisal, and I think, again, the last 2 days have been a testament to the various facets and the various critical questions we may ask about this interplay, but also to have a forward-looking and pragmatic approach to actually move to the action stage and to empower and inspire policymakers to go forward. So this delicate balance, I think, that many speakers have allured to. Some common threads have emerged from this conference, and I'd just like to sketch a very few. The issue of political will certainly has been mentioned by numerous actors. The idea of this people-centered approach and the idea of leaving no one behind as a cardinal principle to inspire and crystallize all of our actions. The context-sensitive dimension of any and all actions has also been highlighted. The need for a critical interrogation of the role of accountability and the meaningfulness of accountability in that process. Multiple actors have been mentioned with divergent and yet complementarity roles to play, from state actors to non-state actors to certainly civil society being a key force in this debate. And going back to the very opening dialogue, of course, the importance of data has been highlighted, and the importance and role of evidence-based policymaking. On the one hand, we heard the need of new data, meaningful data, to be generated in the first place. And on the other hand, we've heard that already existent data maybe needs to be recognized, read, and actually be used by policymakers. This and more will be found in the report that the Nuremberg Academy will put together to capture the key discussions and the critical questions unearthed here at this event. So allow me now to close with the formal thank yous, because all of you have really made this event successful. And I'd like to, in particular, first of all, recognize all of our speakers and chairs for their insightful presentations, their careful observations, and their thoughtful comments all along the 2 days. Thank you very much. Then certainly I'd like to recognize all of you here present in the audience, all the participants, all the audience who have also made contributions by your mere presence, but also by your thoughtful contributions in forms of questions, comments, and informal conversations that have been held all along. So thank you for being here. Then certainly I'd like to thank all the members of our Foundation Board and Advisory Council for your presence here and for your continuous engagement and support with the Academy, and for again contributing to this conference. Thank you very much. Then, of course, I'd like to recognize our partners in this exercise, the Higher Regional Court of Nuremberg and Memoriam, who have again contributed to this event and with whom we have a very cooperative relationship in terms of the use of this very Courtroom 600. And of course, I'd like to recognize also all the staff and service providers who have made the event a 3D event with all the possibilities in the breaks and in the informal sessions. So thank you very much. And then last but certainly not least, I'd of course like to thank all the Nuremberg Academy team who has been working tirelessly on making this conference a success, who've worked behind the scenes or in front of the scenes, and whom you've had an occasion to meet. It's been an absolute pleasure to work with the team and to put together this program. So thank you very much to all of the Nuremberg Academy staff. With that, I'd once again like to thank all of you. It's been an absolutely rewarding last 2 days, very interesting, stimulating discussions. We will certainly take away a lot of things to reflect on in our conference report, but also for the rest of our work in the coming days, months, and years to come. With that, I'd of course like to invite you all to return to Nuremberg. It's been a pleasure having you. The next major occasion of the Academy is the Nuremberg Forum 2019, which is happening on the 18th and 19th of October, dedicated to the topic, the Nuremberg Principles Beyond the International Criminal Court, a common ground for accountability. And we invite all of you to participate in the discussions. So once again, thank you very much for your participation. Wish you a wonderful evening, safe travels onwards, all the best with your endeavors and projects ahead, and see you very soon back in Nuremberg. Thank you.